Hello everyone. In this presentation, the various rules pertaining to the right of private defense as laid down under sections 96 to 106 will be explained. Every civilized system of law recognizes the right of private defense. It is the responsibility of the state to protect the life, liberty and property of the individuals in the state, but it may not be possible for the state to protect every individual at all times and all places. This is the reason why the state confers the right of private defense on the individuals to defend their person and property against attacks when timely help cannot be obtained from the state. But when such timely help is available, no one is allowed to take the law into his own hands. The right of private defense is available only against an offense, and when there is no threat of an offense, there is no right of private defense. It is not permission to commit an offense but only to defend against it. The right of private defense will not be available when one voluntarily initiates an attack or joins a riot wherein he puts himself under attack from others. Section 96 states that nothing is an offense which is done in exercise of the right of private defense, and the other sections define the limits within which the right can be exercised and the extent to which injury can be inflicted on the assailant. Section 97 lays down that every person has a right to defend one's own body as well as the body of others against any offense affecting human body. Section 97 also extends to defending one's own property as well as the property of others against theft, robbery, mischief and criminal trespass or attempt to commit any of these offenses. Section 98 says that if the act is otherwise an offense, the right of private defense arises against the person during the act, though he may not be punishable for the act because of his personal incapacity to commit a crime. For example, a lunatic attacks A, and in order to save himself, A hits the lunatic, causing injury to him. Here, though the lunatic may not be liable for the attack, the right of private defense is available to A against the lunatic. Section 99 is complicated and deals with situations when the right of private defense will not be available. Firstly, it deals with the right of private defense against public servant. There is no right of private defense against a public servant discharging his lawful duties. If his act is wholly illegal, this rule will not apply. But where the act of the public servant is not strictly justifiable by law and at the same time is not wholly unauthorized and is done in good faith and under the color of office, the right of private defense will not be available against such acts. However, if such act causes reasonable apprehension of death or grievous hurt, the right of private defense would be available. The protection afforded to public servant also extends to those who are acting under the direction of such public servant if they are acting in good faith under the color of office, even though the direction is not strictly justifiable by law unless there is apprehension of death or grievous hurt. But where the person threatened of injury does not know that the person against whom he is exercising the right is a public servant, he is not deprived of the right of private defense against the public servant or against those acting under his direction. The other matters mentioned in section 99 are two ordinary principles. One, there is no right of private defense in cases in which there is time to have recourse to the public authorities for protection. 2. The right of private defense in no case extends to the infliction of more harm than necessary for defense against the unlawful attack. Sections 100, 101, 103 and 104 relate to the extent of injury that may be inflicted on an assailant in exercise of the right of private defense. Under section 100, when assaulted, the right to defend one's own body as well as the body of others extends to voluntarily causing the death of the assailant if the assault causes a fear of death or grievous hurt, or of rape or unnatural offense, of kidnapping, abduction, or wrongful confinement in secret. According to section 101, in the case of any other offense affecting human body, the right of private defense extends only to voluntarily causing any harm short of death. Now, when does the right commence and when does it cease? According to section 102, the right commences as soon as reasonable apprehension of danger to body from a threat to commit the offense or attempt to commit the offense commences, and continues so long as the fear of such danger continues. It ceases as soon as such threat or attempt ceases, or as soon as assistance from the public authorities is received. Under section 103, the right to defend one's own property or the property of others extends to voluntarily causing the death of the assailant if the offense that is committed or attempted to be committed is robbery, housebreaking by night, mischief by fire, committed on any building, tent, or vessel used as human dwelling or as a place for custody of property, or theft, mischief, or criminal trespass accompanied by fear of death or grievous hurt. According to section 104, where theft, mischief, or criminal trespass does not fall under any of the above descriptions, the right of private defense extends to causing any other harm short of death. According to section 105, the right of private defense of property commences when reasonable danger to the property commences and continues in the case of theft till the offender escapes with the property or the property has been recovered. You cannot fire at a person who leaves the property and is running away. In robbery, the right continues so long as the offender causes or attempts to cause death, hurt, or wrongful restraint, or fear of instant death, hurt, or wrongful restraint to any person. In mischief or criminal trespass, the right of private defense continues as long as the offense continues. In housebreaking by night, the right continues as long as the house trespass continues. The right of private defense to a person also extends to taking of risk to the life of an innocent person where there is reasonable apprehension of death and the person is so situated that he cannot effectively exercise the right of private defense without causing harm to such person. For example, when A is attacked by a mob which attempts to kill him and he is so placed that he cannot protect himself without firing at them, and he cannot fire without the risk of hurting children who are mingled with the mob. If by firing he injures any child, he will not be liable because his life was in danger due to the attack, and section 106 covers his case. Thus, the right of private defense is available against offenses affecting human body and against certain specific offenses against property. In order to exercise the right, it is not necessary that the commission of the offense should commence or there must be an attempt. Even if there is an imminent threat, the right of private defense commences. When a mob with lighted torches is approaching a house, there is a threat to the life of the people in the house as well as to the house, and in such cases, opening fire at the mob by the inhabitant, keeping it low, resulting in injury to one or two members of the mob, will not make the inhabitant liable for causing hurt or grievous hurt. If the mob still continues to approach the house to set it on fire, firing at the mob and killing an assailant also will not amount to an offense. Thus, actual commission or attempt to commit an offense is not necessary for exercising the right of private defense, and threat, fear, or apprehension of death or grievous hurt is sufficient. The harm caused in exercise of the right should be commensurate with the risk from the assault. When there is time to approach the public authorities for assistance, the right of private defense will not be available. Regarding burden of proof, no doubt the burden of proving the guilt of the accused beyond reasonable doubt is on the prosecution. The burden of proving that the case falls within the right of private defense is upon the accused, and the court will presume the absence of such circumstances. The accused may discharge his burden by establishing the defense on mere balance of probabilities in his favor with reference to such circumstances. So, this is about the various defenses that can be pleaded by a person who is accused of an offense under the Indian Penal Code or under any special or local law. Thank you.